This is Michael Popok, and you're here on the new Legal AF YouTube channel. People are actually dying because of the corruption of the Supreme Court related to the Second Amendment and the right to bear arms. There's a new report out by our colleagues and co-collaborators, Court Accountability, along with Newtown Action Alliance, the fraud of the U.S. Supreme Court's Second Amendment jurisprudence. And I'm going to give you the highlights on it right now. Later on, we'll have some of the leaders of those two organizations doing interviews with us here on Legal AF. YouTube channel. Let's do the numbers. 24 right-wing groups have spent more than $600 million over the last decade to try to influence, to their benefit, gun policy in this country, starting with the United States Supreme Court. They've been aided and abetted, of course, by Mitch McConnell, the MAGA Congress, and ultimately Donald Trump and the right-wing Supreme Court justices that he's added and the ones that were already there before he became president. As a result, 40,000 people a year in America die from gun violence at 116 people per day. Just in 2023, 2,700 people were wounded in mass shootings. Another 700 people died. 80% of all murders in America are committed with a gun. Who do we have to thank for all that and the corruption of the United States Supreme Court and federal courts? The NRA. And other organizations that have taken the place of the NRA and should not be ignored at all because they may be more insidious than even the National Rifle Association. I'm going to break it all down for you on this particular hot take. We got Leonard Leo and raising money for the Federalist Society, donating it to the NRA. And if you think I'm wrong, about the $600 million number flooding in to corrupt our public policy through the United States Supreme Court, the NRA alone, just to get Brett Kavanaugh confirmed, spent $1.2 million in an ad campaign to get him to be the sweetheart darling of the NRA. I'm going to talk to you what happened after that just in the last term alone. $1 million was spent by the NRA to support Neil Gorsuch, also now a United States Supreme Court justice. Don't you think there was a quid pro quo for that? And what did they get in return? What they got is the votes they needed in order to strike down sensible gun regulation of any kind. We'll talk about it just from last term and what we can expect from this term. And so let's do it by the numbers. We've got this all started back in a case named Heller, which Antonin Scalia actually sat on before he died in a hunting accident, one bought and paid for by the gun lobby. Antonin Scalia, who never disclosed that talk about laying the blueprint for Clarence Thomas, in his ethical corruption, he never disclosed that he got a custom-made silver pistol given to him while he was overseas on a bought and paid-for hunting junket, while the Heller case to decide whether the Second Amendment would extend to the right to bear arms, personal right to bear arms, was being decided. That was never disclosed. So don't think this is just the only unethical group of Supreme Court justices that we've had. Scalia helped set the template. Now, in the Heller decision, which came out later, basically that was bought and paid for by the National Rifle Association, that particular decision. Former Chief Justice Warren has said that the gun lobby and the NRA's interpretation of the Second Amendment to write out a well-regulated militia, which obviously meant that the founding fathers and the framers thought that the right to bear arms was only in order to have a well-regulated militia, not to run around the streets with weapons of war and automatic weapons to kill people. They wrote it out. They said, no, that's not what it meant. Don't ignore the comma, ignore the whole prefatory introductory paragraph. Just go right to that second half. The right to bear arms shall not be abridged. That's the part we like. Ignore the beginning part. Under the law and interpretation of law, I learned this in law school, you're supposed to give meaning to each part of a phrase and not make anything superfluous. They made the entire introduction about the well-regulated militia being at the core of the Second Amendment, right? They wrote that out, which allowed subsequent cases like the Bruin decision just from 3 years ago, New York Rifle and Pistol, where the Supreme Court and Clarence Thomas got to say, everybody gets to have a weapon. It's a personal right to bear arms. Not only that, they created this phony historical precedent requirement, a historical antecedent requirement, which means that the Supreme Court, in order to uphold a regulation. The only way you can get a regulation on guns to be upheld now by any state or municipality is if you can find an analog, if you can find an antecedent in history. Oh, the old-timey times in 1790s, early 1800s. Did they have that regulation? Oh, they don't have that regulation. Sorry. Your AR-15 can't be regulated. Your AK-47 can't be regulated. Putting aside all the other historical aspects during those old-timey times that don't fit their theory. And so those stubborn little things like facts, like women were considered owned by their husbands and they were chattel second-class citizens, which this Supreme Court is busy making them second-class citizens again. Women in this country have less rights in 2024 than my mother did when she gave birth to me in 1965. Less rights, or at least less rights when she was raising me after Roe versus Wade in 1973. Okay? And I never thought I would say that. That's this Supreme Court. I'm doing the NRA now. I'm doing guns now. I'll do reproductive rights later. Repro rights later. Now look, you've got the decision in Bruin comes out. Clarence Thomas says can't find it old-timey times. Can't find a lot of things in old-timey times. Black Americans with full citizenship and rights you don't find in old-timey times either. And so why are we using the dead hand of history to regulate what's supposed to be a modern, living, breathing document of the Constitution? They don't want it to be. The right wing doesn't want it to be a living, breathing document. They want it to be brittle. Brittle. You just read what's on the page, except when they don't like what's on the page, and then they read it out. Now you've got, in addition to that, just so you don't think I'm making things up here, right in this new white paper, issued by Newtown Action and the court accountability, that this is a matter of life and death. Let me just read to you what's happened since the lobby groups have bought and paid for certain justices. I'm looking at you, Gorsuch. I'm looking at you, Kavanaugh. I'm looking at you, Amy Coney Barrett. McConnell's over there. Let's just go through it, right? In a 2023-2024 last term alone, the United States Supreme Court handed the gun lobby a number of victories. In Garland versus Cargill, the supermajority 6-3 right wing invalidated a federal ban by the Biden administration on bump stocks issued after the 2017 Las Vegas massacre, in which 63 people died and 400 people were injured by a guy who took an AR-15, put a device on it that changed it from semi-automatic to automatic weapon, which are outlawed in this country. But to Clarence Thomas and the rest, well, it's still semi-automatic, isn't it? It's not. It's semi-automatic plus. But I wouldn't go far to say is it's automatic, and therefore, sure, we're going to allow somebody to fire 500 bullets in a particular minute. In this case, from the Mandalay Bay Hotel, broke a broken window that shot at the Harvest Festival. I was there that night in Vegas when it happened. I met people that were shot and survived the Harvest Festival. I have a special affinity for this particular fraud examination. Let's just put it that way. Then, because they knew they'd gone too far in Second Amendment rights, they dialed it back ever so slightly. A little bit of walking back their extreme positions, a little bit of their damage control in a case called Rahimi from last year, in which the Supreme Court said, well, we don't want domestic violence abusers. We don't want them to be able to own a gun, so we'll find that regulation, okay? Even though we can't find a historical antecedent for that, we'll sort of find one. We'll scratch it and look around, see what we can find, because that sounds terrible that we're letting people with domestic violence histories who are shooting off guns like they're in the wild, wild west while they're abusing their girlfriends. We shouldn't allow them to have guns. So we hate those facts. So let's just give one to the good guy, one to the public, and that was Rahimi. Then they followed it up with National Rifle Association versus Volo, in which they found that New York violated the NRA's First Amendment rights. So now you've got the NRA's First Amendment rights being violated by New York, and New York getting chastised as a result. And then we've got the case we call Loper-Bright. Loper-Bright versus Raimondo, which totally destroyed the administrative state and the ability for the ATF, the Alcohol, Tobacco, Firearms, and Explosives division or regulator, to regulate in the area of gun control. Because once you take away what we call Chevron deference, which comes from a case called Chevron, in which back in the 70s, when Neil Gorsuch's mother was the head of the Environmental Protection Agency, she fought hard to have the EPA's rulings and by its scientists and its environmental protection technicians be given some deference by the courts rather than federal judges who barely passed science in high school making decisions about water and air regulation. Sounds right, right? So they created a doctrine called Chevron deference. It has been the bane of the right-wing MAGA conservatives ever since, because they think that has fueled the rise of the administrative state, where regulations have overcome commercial reasonableness, and businesses are not making any money because of regulations, even though thousands and thousands of Americans are saved every day. Workers by OSHA regulations. People, air and water and food by FDA and EPA regulations. But this court just got rid of it in Loper Bright. Nope, can't have any deference to any of the scientists that work for any of the agencies. Federal judges are supposed to figure that out on their own. This is the beginning of the destruction of our regulatory society that protects you and me. And it'll come back to the NRA and other groups, because it'll destroy the ability of ATF-E to regulate in this area. We've got a new case that's coming up just this term about ghost guns. It's as bad as it sounds. What's a ghost gun? It's a gun that you create with something you've downloaded online on a 3D printer, and when you assemble it, it's a gun that can fire a bullet. And it's not registered, because who's registering these things? So the ATF-E wants to register guns, ghost guns, so they at least can keep track of them. Sounds like a good idea, right? Sounds like something law enforcement, the American people, and people that are dying because of gun carnage in this country can get behind. Not MAGA, because they're bought and paid for by the NRA and other gun lobbyists, and always have been. And the Supreme Court justices too, who owe their seats to the lobbying efforts done by the gun side, the gun lobby group and the gun manufacturers. And so you've got this what appears to be a reasonable, sensible regulation for a well-regulated gun control policy. Why don't we put a stamp and register ghost guns? All those in favor? Any opposed? We got the opposed. And now it's up at the United States Supreme Court in this MAGA right-wing Supreme Court, who are probably likely going to find, well, ghost guns sort of like a First Amendment right, and they're really not guns yet, because you got to put them together later, and when they're in separate parts, maybe not. I got an idea. Why don't you require that the plans that they download be registered, so we know where the plans went? And whether they built a gun or not, at least we have an idea of who's attached to what plan for what 3D printer. How about that? Why don't we register the 3D printers? How about that? How about we know where everybody's 3D printer is? I'm okay with that. I don't see that as a First Amendment expression, that I get to build a bomb in my backyard with a 3D printer. Well, let's find out. Now, it's not just the NRA. Let me leave this hot take and tell you about the National Shooting Sports Foundation. Well, that sounds innocent. The NSSF. Now, let me also just say this in this hot take. I am not against the right of a person under the current law to carry a weapon, an appropriate weapon, for home safety and personal safety. I'm okay with that. Properly registered, properly trained, properly stored at home, away from the crazy crack kids in the house, or the ones that are young and could accidentally kill themselves. I'm okay with that in principle, but not bump stocks, semi-automatic, automatic weapons, AR-15s, 50 caliber weapons, weapons of war in civilian hands, and falling into other unstable civilian hands. I don't want that. And that's what we're talking about. Let's talk about the NSSF to end this hot take. Accordingly, it's been considered even more insidious than the NRA. It wants guns everywhere agenda. Its solution for mass shooting is not less guns, not more mental health counseling and services, more guns. You got shootings in a school, arm the children. You got shootings in a school, arm the teachers. You got shootings in a mall or in a sporting event, arm everybody. Everybody just whips out their gun when the crazy person or the shooter whips out their gun. College campus, arm everybody. Arm everybody to the teeth. This will be the deterrent. Guns everywhere policy. It endorses permitless carrying and concealed carry reciprocity between the states. In other words, you can just conceal carry. Keep it in your back pocket, or open carry. You don't even have to register it. Florida, which used to have a concealed weapons permit law, which was reasonable and sensible, required training about gun handling and gun maintenance and gun safety and gun locks and how to fire a weapon, sort of smart and register, got rid of it. DeSantis got rid of it. now you just have a gun. You have to register your car, right? You have to register most everything in your life that's an instrumentality that could kill somebody, but not a gun, apparently. And so they've been lobbying, and their lobbying for the National Shooting Sports Foundation outstrips the NRA, if you can believe it. The NRA's been tied down and tied back by Letitia James, the New York Attorney General, and has had to file for bankruptcy and fire Wayne LaPierre, its longtime spokesperson. But the NSSF has stepped right up. Same people, same money, just new name, just reskinned, led by Paul Clement, a leading lawyer for gun advocacy and gun rights over human rights, over the right that I don't get shot on my way home today, or my wife and my daughter and my family. And through them, they are filing dozens and dozens of challenges around the country at the state level, ultimately up to the United States Supreme Court, challenging anything that smacks of any type of regulation whatsoever. They find nothing reasonable about gun regulations at all. What can you do about it? That's what I love about working with the court accountability groups. There's a call to action section. What do you do? This is a matter of life and death. We know it. You can call on Congress to pass meaningful court reform, right? They've got the Supreme Court Ethics, Recusal, and Transparency Act, which is up for a vote if blue gets control of the House. There's the High Court gift ban. That's a law that's in draft that's waiting up there. The Supreme Court tenure establishment. No more lifetime appointments. The Judiciary Act could add more seats, up to 13, to the United States Supreme Court from the current 9. These are all things that we can do at the Congress level, but the Congress level can only do it if you give blue the House and the Senate. The Senate to confirm federal judicial positions, and to ultimately pass this legislation originating partially in the House. That's where it starts. That's why I never like to leave my hot takes on the Grim Reaper, all right? I'm jazzed up. I'm excited. I'm energized because we got something we can do in less than 30 days, and that's called vote. And vote the bastards out, and don't vote the bastards in, as they say. So until my next hot take right here, take a moment, free subscribe. You're already here, Legal AF MTN YouTube channel. I'll be curating this channel for you with some great new commentators coming on here at the intersection of law and politics. You can find them all in separate playlists, and don't worry, I'll be driving the train on Legal AF MTN. I'm Michael Popok, and I'm reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.